Good morning, everyone. Welcome to the Thursday, June 12th, 2025 Agenda Meeting of the Minnesota Public Utilities Commission. My name is Katie Sieben, and I chair the commission. The other commissioners who are present today, I'll take the roll. Commissioner Partridge.
Here.
Commissioner Hom.
Here.
And Commissioner Tuma.
Here.
A quorum is present. We have 4 items on our agenda today, and our Assistant Executive Secretary Mike Bull will introduce item number 1.
Thank you, Madam Chair. Commissioners, item number 1 is docket number 2516 in the matter of Commission Subcommittee delegations under Minnesota Statutes 216A03 Subdivision 8. And the question before the Commission is, should the Commission name Commissioner Audrey Partridge Chair of the Consumer Affairs Subcommittee? I have no further comments.
Thank you very much for preparing the briefing papers for this and the recommendation. Is there any discussion of decision option 1, which is to appoint Commissioner Partridge as chair of the subcommittee on consumer affairs, effective tomorrow?
I would move that immediately before she changes her mind.
Yes, thank you. All in favor of Commissioner Tuma's motion, please say aye. Aye. Opposed? The motion prevails. Thank you very much. Ms. Pham, item number 2. Thank you for your work on this. Please introduce it when you're ready.
Good morning, Madam Chairs and Commissioners. Item number 2 is docket number E002 AMS-25-135 in the matter of Xcel Energy's petition for approval of its electric state energy policy compliance and true-up proposal. The question before the Commission today is, should the Commission approve Xcel Energy's petition? Staff and parties are available for questions.
Great, thank you. Commissioner Hom, did you want to begin with questions? Or Commissioner Partridge? Sorry.
I have no questions on this one.
Okay, our Commissioner Tuma?
Yeah, for the company, if they have it, yeah.
Ms. Steinhauser is coming forward. Welcome. Please state your name for the record.
Good morning. Lauren Steinhauser on behalf of Xcel Energy.
Commissioner Tuma.
Ms. Steinhauser. I finally understood netting. It made me think about it a little bit while, but it's going to be netted out in the interim rate refund. So in other words, if you owe ratepayers $10 million in the interim rate refund, you'll minus the 1.35, and it'll be divided up equally amongst the ratepayers through the interim rate. So it should be fair from that, right?
Chair Sieben, Commissioner Tuma, that's correct.
I know this is probably an academic question, but what if the interim rates are only $1 million? What happens to the $350,000?
Chair Sieben, Commissioner Tuma, it's a good question. It is an academic question. Sitting here right now, I don't have a great answer. I'm going to turn back to the support. Got a friend coming up to help.
Commissioner Tuma, I think this just means we must disallow more than that, right?
In a second here, but
Please state your name for the record.
Good morning, Commissioners. Al Krug with Xcel Energy. Just so I'm clear of the question, I think you're suggesting, suppose there isn't enough money for the interim rate refund, then we would simply commit to return we would file some sort of compliance to net this out properly. It wouldn't necessarily have to be done through the rate case. We'd find another method.
I thought you would just say, we'll eat it, but that's
Well, I'm not prepared to say that.
But this points out that more than likely in the rate case, you've asked more money than you're going to get. So at least you're admitting that fact here, that more than likely the interim rate refund is going to be larger than $1.35 million.
History, certainly, Commissioner, history has bared that out, yes.
That's what I thought.
Do we have a motion on the item 2, Commissioner Partridge?
Yes. I would move decision option number 1, number 2, number 3, and number 4.
Is there any discussion of the motion? Hearing none, all in favor, please say aye. Aye. Opposed, the motion prevails. Thank you, Ms. Pham and Mr. Johnson and Xcel.
Yes, thank you. They approve of the new chairs, too. So. They approve of the new chairs. They're more comfortable. Why do we have the old ones? I think we should swap them out, shouldn't we?
Mr. Andriga, please introduce item number 3.
Certainly. Good morning, Chair Stephen and Commissioners. Today's third agenda item is docket number G-011/M-24-269 in the matter of Minnesota Energy Resources Corporation's petition for approval of a change in demand entitlement for its consolidated system, and docket number G-011/M-24-270 in the matter of Minnesota Energy Resources Corporation's petition for approval of a change in demand entitlement for its northern natural gas system. Questions for the Commission today are: should the Commission approve MERC's proposed demand entitlement capacity for the 2024-2025 heating season for its consolidated PGA area effective November 1st, 2024? And should the Commission approve MERC's proposed demand entitlement capacity for the 2024-2025 heating season for its northern natural gas PGA area effective November 1st, 2024? Staff and parties are available for questions. Thank you.
Okay. Who would like to begin with questions? Commissioner Hom.
Thank you, Chair Stephen. So I have a question to company, and I don't know who's on the...
I think it's Ms. Hoffman Malug. Please introduce yourself for the record.
Good morning. Joylyn Huffman-Maligue on behalf of Minnesota Energy Resources Corporation.
Okay, thank you. My question is about the reserve margin. I think I asked similar question to Great Plains in before. So what is the rationale that MERC is having that very high reserve margin in both consolidated area and NNG area? I heard that your argument in that because of uncertainty in the Rochester project, NNG, you prefer to hold additional capacity beyond your preferred 5% reserve margin. But how about the consolidated area? Why are you holding above 10% reserve margin even though you don't have that kind of uncertainty in that area?
Yes, Chair Stephen, Commissioner Hom, thank you for the question. I actually have with me online today the director of our gas supply, Sarah Mead, and she would be best to answer that question. Sarah?
Good morning, Commissioners. My name is Sarah Mead. I'm the Director of Natural Gas Supply at MERC and our other utilities. And very good question, Commissioner. Thank you for asking it. Consolidated is a very small location for us. It is our smallest. We do, I believe it is around 11.6% reserve margin there. And we do expect to and will continue to in the future to release that capacity down to the 5%. Consolidated makes up, I believe it is 3 different pipelines. So some of that gets really small. We always have concerns with our really small areas when you only have, 4,000 decatherms. 5% is really small compared to a very large area, like a Rochester or something like that. But we do commit that in the future we will release that capacity down to get to that 5%.
Okay, thank you. And then now I'll ask some question about the NNG area. I understand Commission made a decision that Rochester project is reasonable for the company to do this expansion and procuring capacity entitlement, and then to mitigate potential excess capacity, companies are doing the capacity release in this area too, right?
Correct.
And then also you sign up the new customer so you can use this excess capacity rather than releasing that, because typically capacity release is not that profitable for the ratepayers. So I think signing up new customers is helping ratepayers on an ongoing basis, right?
Correct.
Okay, thank you. In that process, you are still keeping this capacity at the 10% plus rather than trying to have a 5% due to that uncertainty. What is the rationale that you are keeping that extra 5+% to mitigate that uncertainty?
Thank you for the question, Commissioner. Merck Northern Natural Service Territory is actively releasing capacity. We did release it in the 24-25 to get down to that close to that 5% reserve margin. We collected $1.3 million back from that capacity. So NNG is actively releasing it. We do have issues with it in the Rochester area. It doesn't have a whole lot of value to anyone else. But in areas that we are actively releasing down to that 5% and did last winter and the winter before.
Okay, thank you. So is there any plan for you to bring it down below 10% if you find some counterparty who can take your capacity release?
That's a very good question. What we are seeing at Merck NNG right now is our peak day, which is what we expect on the very coldest day of the winter, is growing. And in 2027, we actually forecast that we'll be short our firm capacity plus 5%. That's Merck's current projection that in 2027, we are going to be short capacity. So at this time, we do plan to temporarily release that capacity till we get to that point, because we know forecasts in the future are forecasts, and we update those and make those more robust every year. We do see in the very near future a shortage.
Okay, thank you. In that estimate, have you considered what's going on at the state? I think at the state, we are actively working on decarbonizing electric and potentially natural gas industry side, and then particularly building decarbonization is a big thing. Under that assumption, do you think still you will have that projection, and that projection is valid?
Yeah, great question. So what we're doing in the near future, so the near future is the next couple of years, is we are using our historical growth rate, and Merck's territory has been growing on our peak day. But once we get a few years out, we significantly reduced that growth rate, saying we realize there's things in the future that we don't know. We don't expect to continue to grow at the rates we have historically beyond a few years. So we are reducing that growth rate in our 10-year forecast. I would say I think it's between our 5 and 10-year forecast significantly to account for things that we believe are probably coming within the state of Minnesota.
Okay, thank you. Can I ask a question to the department? So same question to the department on the NNG area. Have you done any analysis rather than quoting and or repeating what company says? Have you done any statistical analysis independently compared to the Merck's analysis on this issue?
And state your name for the record.
I'm Ari Zwick with the Minnesota Department of Commerce. Chair Sieben, Commissioner Hom, I haven't personally done any analysis. I can ask my colleague Sachin if he has.
Mr.
Good morning, Commissioners. Sachin Shah with the Department of Commerce. Chair Sieben, Commissioner Hom, regarding the any analysis in terms of, we've done the analysis just regarding the design day, but in terms of the growth rate and looking at what has been occurring in Rochester, we haven't done that in this filing.
Okay, thank you. I was reviewing the 2018 order and then associate the testimony from department. Department projection is way off compared to companies. I think based on what I heard today, companies' projection at that time is more in line with today's situation. So shouldn't department redo your analysis to see whether these companies' analysis is holding up, and because it can have a potential huge impact to ratepayers?
Chair Sieben, Commissioner Hom, I would agree that in the next demand entitlement filing, we agreed to do that. We will take a look.
Okay, so I was hoping that department is not just reviewing the filing itself, but I think hopefully department can do independent analysis after you ask the data, and you can even do work with the company ahead of the filing. That way you can save a lot of time rather than waiting for company to file this annual filing and then react to it. I think there is always a venue you can ask company to provide the data ahead of time. You work with the company and do this work before company file. That way you don't need the extension for the comments, and then still you can meet the deadline for the commission issued notice plan.
Chair Sieben, Commissioner Hom, yes, we would be happy to do that with the work with the company. Thank you.
Okay, thank you.
Any other questions for the company or the department? Commissioner Hom, do you have a motion?
Yes, thank you, Chair Sieben. I moved decision option 1, 2, 3, 4, 5, and 6.
Is there any discussion of the motion? Hearing none, all in favor of Commissioner Hom's motion, please say aye.
Aye.
Opposed, the motion prevails. Thank you.
Two places at once.
We're good. If we're ready then, item number 4, Mr. Lobby, please introduce it.
Good morning, Chair Sieben and Commissioners. Item number 4 is docket number ET3/TL-23-388 in the matter of the application of Dairyland Power Cooperative for a route permit for the Wabasha Relocation 161 kV transmission line project in Wabasha County, Minnesota. The questions before the Commission are, should the Commission adopt the ALJ's findings of fact, conclusions of law, and recommendations? Should the Commission find that the environmental assessment and the record created at the public hearing address the issues identified in the scoping decision? And should the Commission issue a route permit identifying a specific route and permit conditions? Commissioner Tuma filed additional decision options on Monday, June 9th, and corresponding maps on Wednesday, June 11th. Commissioners have received these documents, and printed copies are available on the table in the back of the room, and I also have some copies up here for folks that might want to take a look. Commissioner Tuma filed I already read that part. I have no further remarks, but I'm available for questions. Thank you.
Okay, thank you very much. If the applicant wants to come forward, and we'll start with appearances. For Dairyland.
Morning, Madam Chair, Commissioners. Christy Brusvin, appearing on behalf of Dairyland Power Cooperative. I'm joined by my co-counsel, Justin Chasko, and other representatives from Dairyland in the audience.
And for the department.
Chair Sieben, Jim Sullivan with the Minnesota Department of Commerce, Energy, Environmental Review, and Analysis Unit.
And is someone here from the DNR? I have them listed in the back. If you don't have to come up, but there might be questions for you. Or Mr. Runke, I also see. There's a button on the bottom of your microphone if you wanted to just introduce yourself for the record.
Hi, Chair Stephen, Commissioners. I am Samantha Bump, representing the Minnesota Department of Natural Resources.
I should do that again. I did not hear you.
That was my fault. Sorry.
Is it on? Is it one of those difficult ones?
Yeah. Got funky mics. So.
Okay. Sorry. Chair Stephen, Commissioners, Samantha Bump, representing the Minnesota Department of Natural Resources. Any better?
Sorry, my son called me and I didn't mean to answer the phone. And now he keeps calling me back and it's like not a good time, Henry. Mr. Runke, please.
Hi, Nathan Runke with International Union of Operating Engineers, Local 49.
Okay, thank you very much. I just need to take care of this. I'm sorry. I have a little problem. Can we just take like a quick recess, 5 minutes, and then we'll come back and start with questions?
Hi, can I? Well, can we?
I understand. It's okay.
Okay, sorry about that. We're back from our recess and we'll start with questions. Commissioner Tuma.
Ms. Brusman, I have 5 areas of questions, but I don't know if you just want to walk through the decision option that I sent you first and tell me which ones are crazy ideas you want to talk about and which ones are okay with the company that might save us a little time. Not that I ever have any crazy ideas, but.
Ms. Brusvin.
Madam Chair, Commissioners, and Commissioner Tuma, just for starters, the applicant supports the staff recommendations for 1, 3, 5, and 8 from the briefing papers. And I will note, right, that was based on an ALJ report and no exceptions. So very solid record from which to consider the additional items, Commissioner Tuma, that you have suggested. So I'm happy to walk through them one by one if that's what the commission would like to do. There are a few where I think there's some discussion that would be helpful.
What if you just tell me the ones that need discussion and the ones that are okay with the company, and that'll speed things up.
So I think A, C, and F are okay. D is probably also okay, but I have a small item I'd like to discuss. And then I think the other ones, there are just some questions that we have to make sure we understand the intent of the decision option and how it might be implemented if it's adopted.
That helps. That helps out. And I want to start out first just by making a statement. And I already indicated to Mr. Sullivan, excellent EIS. Looks like the record is phenomenal, I'll be honest with you. I was going to say very, very good, but I think you've elevated it to Dairyland folks out there. Excellent work. This is one of the best records to work off of that I've had since I've been on the commission. And as you know, I dig through them quite deeply. I wish I could have said, oh, there's nothing I saw there, but there's always stuff that just pops up and I want to have discussions about. And I'm not surprised the ones that you want to have discussions about. And so I just want to frame it like that. I mean, this is a great record. I think we're going to have no problems getting through this, but I just wanted to make sure we're doing the landowners justice there. So I just want to touch base on what would be the removal stuff, which would be the 6F, and just to make sure that we're tracking. And this is the way I understand it, Ms. Brusman, and you can correct me if I'm wrong, because I look for it in the record, and I could not find the old permit anyplace. Maybe it's hidden in there someplace. But typically, most of these permits don't deal with decommissioning of facilities. If you could put up the first map, Sam, and be the first one, not the second one. First one. There you go. And so, and this did dawn on me while I was sitting there looking at the line, drove down County Road 47, scroll up just a little bit right there. And County Road 27 is being reconstructed, so it was a little muddy getting there, but it was okay. Is when you look at what was proposed, which was the red line, okay, that's very close to where the 345 kV line is. That's that black dotted line just above that beginning of the red line in the bottom. And that's what you're trying to fix. You're trying to get off of that 345 that you partner with and start heading on a different route. And everything good from that perspective. You worked with the landowners, and I thought it was a great bit of work. But all this, I counted 8 structures. It's a little hard to count because it was, so all those little dots aren't structures. That's just indicating a line. So I counted 8 structures, 5 of which are in the fields there, the Youngs farm fields. The Youngs work apparently quite cooperatively with their neighbors to their west, and even the neighbor to the north, where you see all the different adjustments that you guys made to make the modified route, which looks great. So that was a bit of great work on your part. I wish there was another company that was doing the same thing over the Redwood River right now, but that they did a good job working with their neighbors. I'm hoping Xcel does the same thing. They should look to you guys as an example. But this is a great bit of work, but it was unclear to me what to do with those 8 structures. And so I'm suggesting putting it in this permit for the very reason that it's in the permit and allows the Young family, who bear most of those structures, to be able to work with you to make sure it gets returned back to its prior use as a farm field. When I read the application was mentioned it, but it was not addressed anywhere in the ALJ's findings or in the ALJ's discussion about what you're going to do. And basically the application says, we'll dig it down 4 feet unless we don't want to or can't, okay? And so I thought that was a little vague. So I'm trying to create a little, meatier language to say, work with the landowners, don't just put gravel in the hole, give them a farm field back, is what I'm trying to say. And so I just want to make sure you're okay with understanding that's why I'm putting in the permit, so they have a right to it, and it's part of the complaint process.
Ms.
Madam
Brewster.
Chair and Commissioner Tuma, yes. And, when we filed the application, it was obviously the applicant's preferred route, the red line on the map that's on the screen. And so there were far fewer structures to be removed, which is why you saw not much discussion, right, in the application about that. Because if you're looking at the map, it's right where the kind of triangle comes together and those black dotted lines continue off the map. That's where the 345s are co-located going forward. So you're right, there are roughly 8 structures now that would be removed from between where that kind of purple line, the RSA AAA2, leaves the 161 up to where that 345 then joins back together again. And in this case, it is our intent, and it was Dairyland's plan before this decision option, to remove those structures just to make sure that the farming operations that continue around them will be safely done in the future. And we have confirmed that there aren't any other utility purposes or other infrastructure hanging on those poles. Right, that might be a situation where you'd have to further evaluate. But in this case, when the company made the move to the RSA AAA2 alternative, we were able to confirm that there's no other utility purpose for that, and the intent is to decommission that line and return it to the landowner for farm operations.
And I had every confidence you're going to do that. It seems like you've had a good working relationship with the Young family to date. And so, but I just wanted to make sure it was in the permit and it was clear, because it really wasn't dealt with in the record. And it's something a little bit different than what the application had. So we're there. The second one, if you could scroll to the second map. And I just want to have a discussion. There's no decision option on this, but it's on the distribution lines. And I'll start off by saying kudos to the company for willing to work with Xcel's and Peoples, who are the distribution co-op and Xcel distribution companies in the area. And there's a lot of discussion in the record and in the ALJ's order, making it very clear that the intent is to, along 42 and 86, which is not on this map, that's over by the substation. But there's all this discussion about 42 and 82, removing it, and I think, and burying the distribution lines. And so I was phenomenal that you're willing to do that, and it's working out. So the first question I have for you, is that still on track? It's not in the permit, and I don't think it needs to be, because it's in the record that that's what you're going to do. And to me, and for I think the record for the ALJ was, that's a big part of why I think we should approve it, is because you're making that significant benefit to the community there that would be otherwise. So I just want to make sure that you're on track with Peoples and Xcel's, that that's still going to be the plan.
Madam Chair and Commissioner Tuma, that is still the plan. Obviously, we needed to wait for the final route permit and routes in order to finalize those plans. But we have had ongoing conversations throughout the application process. And again, where we're along 42, it really does make some sense to try to reduce the number of utilities and make some room for the 161. And so, yes, we're still on track with that, and those discussions are ongoing. They'll be sort of finalized when the route is finalized. And I would say historically, the Commission has not included distribution-related conditions in its permits because they're under 100 kV.
Unless you're fighting us, and then we do it.
So, yeah, but yes, I would agree with you. The record, it is the intent of Dairyland to bury those with the cooperation of the 2 distribution co-ops, and that's still on track.
And then I think you have displayed a couple of photos from the record. This is in the record, and just looking at it, Mr. Sullivan, thank you for the photos, were very helpful and orientating. This is at the end of People's distribution line, actually just up the road would be north of, or yeah, a little north and east of this business is the Xcel territory. So it actually is kind of the end of People's here. And so you can kind of see the distribution lines here. And the reason I show you this photo is one of the complaints was from, or concerns laid out, was this landowner here who said, it's going to change the character of what I look at. But when you look at it, and you're going to be putting essentially the way the route is now aligned is along that existing distribution line. Those go away, your line replaces it. They're just going to be a little higher and bigger and longer.
Madam Chair, Commissioner Tuma, correct. They will be taller with longer spans, but along that same area. And the record also shows that based on the comments from the owners of the Cowpoke here, which is on the screen, we are evaluating an alignment shift that would go to the other side of the road, but also working with the landowner over there to make sure we've addressed any concerns on that side.
My next question, that you could still move it over if you choose. Flip it to the next one, Sam. I think that's, again, it's a little better. This is from the record, it's photo 25. And it just shows you what I found interesting here was the right-of-way alignment. Now, it could be how much the farmers have decided to squeeze into their fields into the state right-of-way, but at least on the side of the road where this is, there's a pretty good right-of-way that exists there, a pretty broad right-of-way. And again, you would be following right along this existing route if you were to continue the existing route. And I think it's fine where it is. I think the alignment is fine. I didn't feel a need to change the alignment to accommodate them because I think you can work it out without it. That was just my opinion. It looked like a good choice of directions. Certainly the other side of the road is there's less people there and the people are a little further back, but I didn't see it to be anything that would cause me a problem. But I just wanted to make sure we're on track. Those poles are going to disappear. Your poles are going to replace it.
Madam Chair, Commissioner Tuma, correct. That's the intent.
Another thing on the distribution, if you could go back to the second map, Sam, that one exactly. This is the B route. Another good working with the landowners. I knew when this came through, and I took a quick look at the maps when it came through for even though I think it would consent calendar if I remember right, but I think Sam showed me the maps, and I knew this was going to be one of my pinch point areas. And really good work with the landowners. When you look at it, this was the best route, and it certainly, even though there's one house just to the north of that where the B cuts across the field there, you can tell it's not in their view shed. It looks really good. The farmers who own that field and own that dairy there just to the south were willing to put it just to the north of their property. Worked out great. So good work with the landowners. I think this is a great route. One of the things that's not on this map as good is that when you take that B going north, that's County Road 42, okay, or from County Road 42, or on State 42, excuse me, on County Road 14. So where it goes from 42 there up to the B, there is distribution lines there. Now, there's not a lot of people that are impacted, but there was a lot of talk in the record about distribution lines on 42 and 86. Is it the intent to also work with Peoples in this case to bury these distribution lines along County Road 14?
Madam Chair and Commissioner Tuma, we will be having conversations with them about this. Again, this wasn't part of our initial conversation on design because it's a route alternative, but we'll work with them at some of that distribution comes north on 14 and then turns, if you will, on 580th. We'll have to talk with them from a design perspective to see if it makes sense to bury it, but we'll have those conversations and work with them to see if this is an area where we can bury it as well.
But just so I understand from the company, it is your intent, assuming technically feasible to do, is to work along 14 and bury the distribution line so we don't have two sets of lines running down that road.
Correct.
That answers that question. Now let's get to one that is a little more challenging. That is decision option 6A and 6B. You're okay with the vegetation management plan, letting the farmer or let the tree farmer do his thing under your facility?
So, Madam Chair and Commissioner Tuma, it's unique to have vegetation under a transmission line in the right-of-way. The circumstances here are unique in that it's a very managed vegetation, but it also needs to be harvested with pretty tall equipment. And so that is something that we have been talking about. Dairyland has some very limited experience working through a vegetative management plan in a similar situation. I just want to be clear that if that is something that we're able to reach agreement on, there will be height restrictions on the Christmas trees and the work underneath it, and there has to be a clear travel path for operations through there. So it's something that we're willing to entertain and work with them on. Their comments in the record had suggested that the oak trees that were on the property were sort of a higher value for preservation. And so it may or may not make sense, but it is something that we're willing to have a conversation with them and see if we can work it out. But I just want it to be very clear to the commission that if that is allowed, it will be a fairly restricted use under the transmission line.
And I'll point out that,
Excuse me, within the right of way, not under the transmission line.
right. And moving it around, that's why I suggested again with 6B, just a more space. I'm not sold on this. I think your alignment is perfectly fine. And we'll talk about the dairy farm in a second. I think it's even fine with the dairy farm. I think the alignment's right. I'm not trying to move the alignment. I don't have enough visual into this other than I can tell you I sat on that, can't hardly see it, but it's 608th Street, the white line going south on the very right side of that blue segment there. And I didn't know what that was. When you look at these maps, you don't know if it's uphill or downhill, but you can tell by the farming technique there's a hill there, and it's down. I mean, Wendy and I are going to probably go back there this fall because it looks so cool. Once you sit there, you go down into some historic, deep, I think virgin timber in that area. So that area where it's cross-checked green, and also that's the state land there, the bright green, the neon green, is actually state forest. And so the alternative routes, all who went through there, no, totally right decision. There's no question about that. But I don't know where this oak trees exist up here for them. And so that was why I was suggesting a broader area to talk with these landowners. I don't know exactly where the tree farm is because, frankly, there are some trees that invasive species, which are the Christmas trees that grew up so you can't really see into the area from the road, and I don't go on people's properties. So I couldn't really see it, and it's hard to tell here. So I'm not sold on this. I don't really think we need to do it, but if your company is willing to talk to Mr. McMillan and then the Miller Dairy Farm, who wants it a little further away from his farm, and you did that already. So just so people know, if you read in the record, he talked about building $1 million, multi-million-dollar new facility. Where you see the 42 there, right there, there's just to the left, that first yellow dot is that multi-million-dollar dairy barn that this guy just built. And you're moving off the road, further away from it, so kudos. The Millers, a different Miller, but I'm assuming they're all a part of the same conglomeration, own that field. I don't know if there's places that they would want to put the poles to move it further away from the barn. And it will give you a shorter route. It's kind of a possible win-win there if you could do it, but not having to come back to us for an alternative, So I'm just trying to help you out here, but I don't really need it. I mean, it's not important to me.
Madam Chair, Commissioner Tuma, I think, again, as you indicated, that we have a very solid alignment. We are working quite a bit with these landowners in this area. I see this additional route width as a little bit more flexibility. If there's, again, a slight shift, that makes it even better. So the company is supportive of the additional route width. We may end up on this alignment, but it does give us a few more options with talking with those landowners.
Excellent. The other one is that we need to chat about is decision option, essentially what amounts to the, I have 6C and D, and you seem you're okay with that. I don't know if you have any questions on C and D, but.
I do. Madam Chair, Commissioner Tuma, and this is maybe more of a me question than even a Dairyland question, but the Section 5.1 of the route permit is a standard condition. It is a timing with which we send out route and site permits for all of the permits that the commission issues within 30 days of their issuance. And then, again, there are typically separate provisions to make sure we're contacting landowners before entering their property. And so it would be helpful to hear what the intent of this change is, because it would make this permit unique among others that the commission has issued.
It is boilerplate language. And my assumption of the boilerplate language is this. Right now it says 5 days before construction, which kind of shocked me. I never saw that language. I saw it, but it just, as I started to think about it with relation to this property, it's like, boy, we want them to know right away. But of course, we obligate you to do it 30 days before. My guess is the intent was I'm building some big line someplace, and I go out there in a field, and some landowner comes out with their shotgun saying, "What you doing on my property?" You know, no one ever gave me notice, and that allows the company to give them the permit then, and then only come back after 5 days after they have a chance to cool down. That's my guess is what that was meant for, because you're supposed to give it to them 30 days after our order.
Madam Chair and Commissioner Tuma, my understanding of the history of this is actually a little bit different. It is 30 days after, but I think if you go way back to the day where we would have the pre-construction meetings in the back of this room after you had an order, sometimes construction could occur very rapidly after your order was issued. And so it was in no case would a landowner get it more than, less than 5 days before you were actually starting construction. I think if you check across your dockets, you'll find that applicants provide this within, with their route permits or site permits within 30 days of the order. You'll see a compliance filing shortly thereafter. And given the other pre-construction compliance filings, there's actually usually a month or two, sometimes even more, between when that goes out and when the actual construction begins. To me, I think that the landowners have actually more notice under the way it's drafted now, because we will send it within 30 days of your order. And then there's plenty of time. We have land acquisition work to do, other things. Then when we arrive, the landowners already have your permit. They know what route's been issued. They understand the conditions, and we can have a great conversation with them.
Maybe that's where I need to be clear. I intend you to still send it 30 days after, okay? I was putting an extra step in, an earlier step, to require you before pre-construction to reconfirm that you sent it to everybody. And here is my thinking behind it, because that was trying to be very clear, no less than 30 days prior to pre-construction. So I wasn't taking out the 30 days after issuance language. I was trying to say that button, if we didn't get it to you earlier, we have to give it to you within 5 days of construction beginning. And I'm saying, no, give it to that. If we didn't get it to you, we got to get it to you earlier. And this is where it's a little difficult, and this is why I think it's important for this particular route. It's short, one. You've had good landowner interaction, okay? The part that is on the other side of that is, when I looked at the record, the most complicated area that you have to go through is when you get to the bluff and you go down through that gully, okay? And I couldn't find anywhere in the record where those landowners had any comment, okay? And so you probably have been talking to them. It probably be a good thing. You've already worked it out with them, and it's not a big issue, okay? But I don't know that. You had a broader route width there to give yourself some space to work down the bluff. Positive. But from this position, from this seat, where we're sitting, I'm not seeing insight of what that looks like. And those are very important landowners that I don't want to find out 5 days before construction they're getting the permit, that something happened. I want you to make the extra step to confirm to us, yes, we've got the permit to every one of these landowners. And yes, the Hagers, I think it is, got the permit, okay?
So, Madam Chair and Commissioner Tuma, if you do nothing to 5.3, if you leave it as it is in the permit that was part of the EA, once your written order comes out and we have the route permit, we will send that to all of the landowners within and adjacent to the route that you've approved, including the areas like this one that's still on the map that are wider. And then we will file an affidavit of mailing in e-dockets as a compliance filing that demonstrates that that's been done. And that is usually done even within that 30-day window, but it will confirm that the mailing itself went out within 30 days of the order. So I think you'll have assurance in the record that it was mailed. If this is a suggestion that we need a second mailing, I would hope that we could clarify what that would be.
No, because that's not what the order says right now. The order says basically, send it out just like you said, but if everything doesn't go right, I can give it to you 5 days before construction. And because of the unique nature of where you're going through and the significance of that area, I'm looking for C and D kind of combined. Is you're keeping us informed what's going on, and if for some reason you're finding out landowners you didn't know about, I guess I'd like to know about that before pre-construction meeting, so Mr. Sullivan and Mr. Lobby can be aware of that and keep us informed that we are reaching out. Again, the landscape of people you got to talk to is a lot smaller than any other place. So no, it's not my intent. My intent is to actually have you do one extra little step in there, which is to let us know prior to pre-construction, yes, we've got everybody.
Madam Chair, Commissioner Tuma, I'm going to repeat back just so I understand.
I
So
apologize.
again, we will mail within 30 days of your order, and shortly after that mailing, we will e-file an affidavit of mailing with the list of landowners who received it. You would like that affidavit or confirmation again before the pre-construction meeting, referencing back to the original mailing.
Right. For 30 days before the pre-construction meeting, we've double-checked everything. We got everybody. We've been talking to landowners.
I understand what that would be, and that's something we can comply with. Again, I feel like 5.1 has us covered, but I understand what you're getting at, and that is administratively possible.
I don't mean to be difficult here, but just it was just the gap in my mind in the record there is that going down the bluff, and that seemed to be the most significant area, and I'm not seeing any conversation in the record very clear on it. I agree with your alignment. I agree with the choice of where you took it, but I just didn't see a lot of interaction, and so it'd be helpful to me, and I think helpful to the commission to know you're having those conversations. That's what I'm trying to get at.
Can I also address D, if that's part of the conversation you're having? So I think it's becoming more common for the commission to ask for updates. Monthly is okay, but I think quarterly here will be more meaningful because it'll allow us to have both the conversations, go back to engineering, work on the design, and then report progress. And so our suggestion would be to modify the decision option D from monthly updates to quarterly updates.
Sounds like a great idea. I just put it in there because it sounded good. So, sure. Oh, my apologies. I should take a break. I'm running. I'm just chitting these off and trying to get done. But my apologies.
No, that's okay. I actually wanted to go back to C and clarify. I think I had misread it based on the conversation here. So the change on C would require a second compliance filing to us? Okay. So the first is to say we sent out the notice, and the second is to say we sent out the notice. And sorry, what does that get us? Is it a double check?
Double check, yeah. And the reason I want to double check is I just didn't see enough in the record about these people that are in that valley that I just want to make sure they're saying, we did talk to them, and I want the record to reflect it.
Okay.
Yes, we did double check the record, and these are the landowners. You get a lot of times where these lands kind of disappear into different people's hands, and particularly when you get in these bluff country. And so I just want to make sure that they really carefully looked at the record is all I'm just saying. So
and Commissioner Tuma, did you consider having that just for this specific area and not all landowners, or is it too hard to parse out then?
That's what I thought, but it wouldn't bother me to say it along that bluff where they have the expanded route width. And that's kind of what I was trying to hint at when I said particularly amongst our, particularly in the areas where the route width is expanded.
Oh, it does limit it to just that area.
Well, no, that's just it's just kind of an extra statement. So it doesn't limit it to that area. It's just make sure the reason I'm doing this is because of that extra route width is why I was saying it, but it does cover the whole route. So, but I have no problem limiting it to the bluff where the expanded route width is.
I mean, I have no problem with this because the applicant said that this is something they can do. I guess I don't understand how it really, what it accomplishes, that maybe there's some other way to say, double check this particular area, like the chair has said, I don't know if there's a particular thing, that you're concerned about in this one area. Is there some additional step you want them to take? Because just refiling the same thing wouldn't be all that valuable. We would want, unless you want them to do something extra.
I do want them to double check it because like I said, when I didn't see on the record the comments from the landowners that I thought were the most impacted, it shocked me. So I don't know what the situation is. Who knows? I mean, I've seen situations where people have come up and said, "Why is this person on my land?" And they didn't realize that the notice was sent to grandma, not to them, and they've been buying it from grandma quietly behind the scenes. And that happens a lot in this bluff wasteland area, so that's what I was worried about.
Would you want to, not to further complicate this, but would you want to just say something like, in the second filing, verify that you have made contact with affected landowners along this particular line? I just don't want it to be just like a rubber stamp. We just filed this thing and now we'll just file it again. If you really want them to take an additional step, maybe it would be worth clarifying the step they should take.
And this was I figured because it'd be confusing, this is a conversation we would have, and so I think the applicant has it. So
Sure.
unless Ms. Brusman has some better language, which I'm always willing to listen to, I do want them to make an extra effort in that area to make sure they are talking to the landowners. I don't know how you say that.
I think it's important to kind of limit it to this area too, because we don't want it to be like, oh, in the next transmission line, we did it this way. So now for everyone, so now we're setting a new process by
I agree
putting
with you
this
there
extra
because they have
step
done
in.
such a good job in the other areas that I don't want to, I don't want to say they've done a bad job. I don't think there probably isn't anything bad here. It's just, it was a gap in the record, so.
Ms. Brusman, how would we limit it to what Commissioner Partridge suggested or what I said about just this area? And if you need a minute, you can tell us that too. We can come back to it.
Use the language, no less than 30 days prior to the pre-construction meeting, that underlined language in C. Shall file, and then I would say that the thing that we're going to do then is, making a filing, a compliance filing, noting that they have verified that landowners within the widened route widths have received a copy of the permit and complaint procedures.
That sounds good.
I would say widen route width on the bluff or something like that. So it is different from, I know you've already talked to McMillans and Millers, so I don't need that. So.
And Commissioner Tuma, how many landowners are we talking about here roughly, just to give me a sense?
Well, the best I could tell is 3, but it was a little bit hard to tell.
Hang on, readjust.
Readjust. Follow Tuma's insanity.
Within the widened route width along the bluff, did you say Commissioner Tuma?
Is that in the right spot? I'm sorry. This report should be amended to require the land.
I think we want to move it.
Yeah, I think it should be.
Within the underlined right after.
Right at the end, yeah.
And then,
Yep, right there.
So this is saying, Ms. Brusman, that essentially you'll confirm that within the widened route, only along these affected landowners in this area will get this like additional check that they got the permit or the order from the commission and are aware what's happening.
Madam Chair, that's how I would understand it.
And then I think also then delete particularly, just put in the areas, alignment in the areas on number D. So D.
Okay.
That way we're just dealing with the Millers and this bluff country then.
Also, through the power of technology, there are 3 landowners along the bluff. We have talked with them, and I'm assured Mr. Hager, who's probably most affected, is a hardworking farmer who we've talked with and decided not to take the time to come to the meetings.
Sure.
But we will.
They're so fun. I don't know why he didn't want to come.
I can't imagine anything else that would be better.
Right.
One wording, so would it make sense to say just verifying instead of detailing compliance? You just want them to say, we have verified that we have talked to these people? Or do you want them to provide a detailed description?
I want to provide a little narrative of how it's
Okay.
going. Yeah.
Okay.
Excellent.
So C and D kind of read together, even though we have them separate letters here, Commissioner Tuma, but I think the way you explained it makes, I'm tracking.
Good.
And, everyone's good with it? Okay.
Now, decision option 6E. This is just a route alignment change. But he presented it, Mr. McDonough, Barton Vivian, presented it and it kind of came across as an alternative, and then we didn't study it as an alternative. And then when that came across, it was like, we don't have to study it as an alternative. It's already in the route, so we've studied it. Looked at this closely, and I agree with Mr. McDonough that following the property line between where the solar panel owner, which is the Peterson farm, and his property seemed to make the most sense. The distance between County Road, or US 61 and Old 61, according to at least the Beacon Maps measurement, which is not the most accurate thing, along your route would be 1,050 feet. So more than likely there's going to be a pole someplace in there. And show the display, if you could, Sam, the picture of that was in the EIS.
Are you looking for photo 48 from the packet?
I think so. In the packet. This one right there. So essentially, as you're sitting there, we're a little bit north of where the alignment's going to be, but the pole is going to be someplace out in the middle of that field. Okay, there is and it's not a direct line, but if you can see it, there's a property line there between the Peterson residence, the Wingnet residence, is a more expensive house that lives to the south, which is quite a ways away from where the alignment's going to be. And the solar panels are 250 feet from the boundary line. So I was struggling when I looked at our standard, which says, for our factors to consider, that we're supposed to follow natural division lines and agricultural field boundaries. And then the statute even says stay out of the fields. Basically, it's saying stay out of the field. And so I'm struggling to find where in the record I would want to move from this alignment. That should be the alignment based on our standards, and I couldn't find anywhere in the record what made it so necessary for us to put it in Mr. McDonough's field.
Madam Chair and Commissioner Tuma, if Mr. Labby, would you mind going back to the map of 6E? So there's a lot going on in this particular area. The crossing that is shown as the red line on this map, which was the one that, the crossing of Great River Road, which is a scenic byway, was something where Dairyland worked quite a bit with the Mississippi River Parkway Commission on a specific, there's visualizations in section 8.2.1 of the application where they really wanted to minimize tree clearing as they crossed that scenic highway. And so the current alignment sort of shoots through a gap. It widens it a little bit, but shoots through a gap in the trees there now. And shifting farther south would have the potential, and it's sort of evident on this map, of taking out some more trees at that crossing. I'm not sure if it'd be determinative, but it would require additional engagement, I think, with the Mississippi River Parkway Commission and others perhaps on that crossing change. The other piece is on the other end of it, right? We have the railroad, we have a driveway, which you can sort of make out as that kind of grayish diagonal line along the marking for the Canadian Pacific Railroad that curves. And so the current alignment, which again is the red line, tries to peg that pole on the inside of that curve, just from a safety and a feasibility perspective. It's a better construction location for that pole. Both of those things with the offset from the property line actually help. And there's another item, there's the property that's sort of a it's kind of a, I don't know what my shapes, my mom will be mad, she's a second grade teacher and I don't know the shape, but there's a property right underneath the old US Highway 61 label. And there's currently some activity, some construction activity on the north end of that, which would be right near the property line. It's unclear to us whether there's a building coming up or whatever it might be. And so for all of those reasons, the current alignment seems to avoid a number of potential impacts, recognizing that there is the potential for poles in that field. But if we followed the alignment that, Commissioner Toomey, you have on the map that's proposed, there'd still be a pole in the field, it'd just be on the property line, right? So as we were balancing factors through that pretty congested and somewhat tricky area, this offset from the property line actually helped minimize impacts on both ends, and that was what drove the alignment that's here. We do have the widened route width, so we, folks from the team have been in the same fields you have been working with landowners. We're trying to minimize the number of poles through spanning in that field, but I think this level of detail would be unusual for the commission to make the decision on, but also you have given us some flexibility here, and now you've given us some indications on how we should maybe look at this as we're continuing to work with those landowners. But I just want to point those things out.
Here's where I'll disagree with you. I do have an imperative in the statute to avoid doing this. Now, you've given me some reasons, but none of them necessarily are determinative of not putting an alignment in his field, at least, so that it is outside of his field on the property line. You could easily, and first of all, your red line actually goes through woods. Okay, I saw it there. It didn't look like much other than some wasteland growth from when they piled a big pile of dirt there from when they built Highway 61, the historic, beautiful line. It's not all that beautiful right there. So just so you know.
Folks on the Mississippi River Parkway Commission might disagree with you.
Might disagree, but
widen an existing gap rather than create a new one.
You could still avoid those trees, still put it on the property line, and still avoid that driveway, which I couldn't go down, by the way, because it's blocked off. And even though it says it's a road, it's not a really road. It's actually an old gravel pit. So I'm not too worried about the old gravel pit driveway because no one's using it, apparently. The other one that caused me problems with your alignment is right where you see that 10, okay? That's milepost 10. And you can see a distribution line coming down and ending right there at 10, okay? And if you look very carefully, it's kind of hard to see, those purple lines are property lines. And so there is a lot, a 5-acre lot that runs from the dotted line, which is my suggested route, okay? And goes over to the railroad, goes north, cuts across, 5-acre plot. Only Ms. Guza, G-U-S-A. If I'm saying it wrong, Ms. Guza, I apologize if it ever comes out in the record or a proceeding. And I'm looking at that 5-acre plot that obviously must be developable because it's got a power there. Ms. Guza actually is not an unsophisticated landowner. She owns hundreds of acres just north of your substation. That's the reason I know that, because when I was looking at your substation ownership, she appears, you don't have to take any property from her there, but you do here. She owns lots of property. Recent widow, because there's an affidavit of survivorship as the last transfer for that piece of property. I got 5 acres there that you're cutting across the 5 acres. Now, I'm not her attorney, but if I were her small town attorney, I'd say, you know what, let's go for the whole thing. I know this is not by the farm, but they're taking your property. They're dropping a power line right through the middle of your 5 acres. It becomes worthless now. That's less of an argument if it's on the property line. And I think there's enough adjustment that you can do with the old gravel pit road, okay, and not these landowners. These landowners seem to be burdened on more than anybody else in this project because you're going to put it in their field, which is exactly opposite of what we should be doing. And I think there's following this route and adjusting from that, okay, is what we should. That's why we have route alignments. We're saying to you, this commission values protecting his boundary line, and if you need to make an adjustment for the scenic byway folks, you can move the route a little further north and cut across down to this property line. And so we can have our cake and eat it too here by just using this alignment, and then you make the adjustments for the other folks, the gravel pit and the scenic wildlife folks or scenic roadway folks. okay? That's to me what I'm suggesting doing. We follow our standard first, and then you can make adjustments from there. But to Mr. McDonough and Bert and Vivian, you're right. It should be on the property line here and figure it out from there. Work with you from there. That's what I'm trying to say.
Ms. Bruisvin, was that a question, Commissioner?
Well,
Tuma?
it's my argument. The small town attorney saying it should be there. That's our obligation. That's the way I see it from this one commissioner's point of view. I don't know where my friends are over here, but
Well, your friend over here is a little like, we have a selected route that seemed to have a lot of agreement and support for. So now, one thing that's not really clear to me is Mr. McDonough, the farmer, like really upset about this one pole in his field, or do we know that? Like, are
7324 made a filing, says would like to provide to move the line south on the property line. So he's made a comment.
He said he wants the line moved, but, when you're reading his comment, did he make the comment at the end as an ALJ report, after the ALJ recommendation came out? Or is this like earlier in the record when he's like, yeah, all things get, from my property, please don't put it here. And then during the process, and I'm not as deep in the weeds or deep in the maps as you are, Commissioner Tuma, but what I heard Ms. Bruisvin say and what I read in the record is there's a lot of agreement between this alignment, and he might not like it one pole in his field, but if it, us just like moving it now will have, it's not as easy as just saying like we can move it and then others, there won't be consequences to that. So
Madam
that's
Chair, actually, it is that easy, and we have an obligation under the statute. That's the point I'm trying to make is the statute makes it very clear. Don't put it in ag fields. The reason we had issues in the past where people were cutting down power poles was because people just plowed them right through ag fields. And so we changed the law to say, don't put it in an ag field. Now, she's raised on the record other things that I think are interesting concerns, but I think they can be worked around and we can still stick with our obligation to Mr. McDonough to put it outside of his field as a first option. And certainly I can, argue that it's better from multiple different reasons, and they can argue for multiple different reasons. I fall back on the statute. The statute says, don't put it in the field. I don't feel there's enough on the record for me to deviate from that obligation. I think they can, and they can work with Mr. McDonough starting from the property line, but then they have to work with them and figure out where that route should be bounced.
Can I ask
Commissioner Partridge.
Thanks. Okay, so just backing up, high level, from my understanding, tell me if I'm wrong, the proposed TUMA realignment is within the range of flexibility already approved for not approved, already suggested by the applicant's preferred route here. It is only a few feet off, right? So it's within that margin of flexibility. Is that right?
Madam Chair and Commissioner Partridge, that's correct.
Okay, so just backing up high level, either of these would allow for poles to be placed in either line. And so instead of, and I agree with Chair Steben that my concern is that, it's like a sweater, you pull the thread, and where does it stop? We know that Mr. McDonough wants it moved on the property line. I think we've heard from many landowners that's their preferred spot is on property lines, so that makes perfect sense to me. However, I understand there are other considerations here. I wonder if there's a way for us to just encourage the company to work with Mr. McDonough and the other stakeholders to do their best to meet everyone's needs. I mean, it's either way we approve this, we're providing the opportunity for those poles to go on the red line or the dotted line.
Right, and Madam Chair and Commissioner Partridge, you're right. Everything you said is right. I'm putting the burden of proof for Mr. McDonough, okay? They can move it off of that alignment that I've suggested. They can move it off of their alignment as I suggested. But this makes Mr. McDonough in a better place. It makes our statutory obligation in a better place. That's the starting point. If there's good reasons to move it and they can work with Mr. McDonough to move it, then they'll move it, okay? And I understand the scenic byway situation. They can easily just shift it off there. But still, it starts with the presumption that Mr. McDonough gets it on his property line first. And so that's the decision we're making. It can happen either way.
Doesn't your language say that that the landowner gets to agree? Yeah. So what if he doesn't agree? Like, what if he's like, I don't want it in the middle of my field? The applicant doesn't have a lot of choice. They have to move it. So you're essentially giving the landowner veto power over where the pole will go.
In this situation,
And in that case, like, it's fine if the applicant, in my view, is like, yes, we can work within that and find a place alternatively to place it. But what I heard Ms. Brusman say is if we don't put it where we're in the middle of the field, there are going to be other consequences to others. And
let me show you why.
Okay, I understand you don't agree with that, but like, I think we need to take the time to hear from the applicant and others to say why they don't agree with you.
And here's why I'm going to suggest. Okay, look at my dotted red line and the red line. Okay, let's assume
which one?
Right here on the map. So the dotted red line, that's my suggested alternative along the property line. The dark red line is their suggested going through the field. Okay, if you simply, not that hard. Okay, if they do have to avoid trees on the other side of 61, okay, they just put that corner pole a little further up by the word trails, okay? They make a slight jog to the south to hit the property line. That's about 1,000 feet right now, right in the middle of that Mr. McDonough's field, okay? Mm-hmm. Then they put another pole over on the property line over there, and if they have to make an adjustment for that driveway, which I'm not convinced of yet, okay? All you're doing is just going down 5 feet, up 5 feet, okay? It's more than 5 feet, it's like 50 feet, but you're just, and we do this all the time. You see this and you drive by any of our major things right now, they do this all the time, okay? Mm-hmm. That's all we're doing is saying the presumption is property line first. If there really is some other reason why you have to have it other than saving 50 feet of conduit, okay, then you need to be more clear on that. And that's putting it on the property line, which is our job. And they can make the adjustments from there because it's all within the route width.
Sure. Ms. Brusman.
Madam Chair, can I make a suggestion? I think I'm certainly hearing the intent of Commissioner Tuma to be on the property line. I think there are a number of constraints, the slight jags or angles, which we try to avoid where we can, both from a cost and an impact perspective. But it is our intent to work with him to minimize impacts to his farming operations. Could I suggest something, a change to E, maybe to just say that the permittee shall work with the McDonoughs to place power poles on the property lines and to minimize placement within the field to the extent practicable?
Yes, and then I would like to add
Wait, let's.
Yeah, so yes, but if, and there's a but if, get to the right place, we would adjust D to say the expanded route width and the McDonough Gusa property, Gunna/Gusa property.
Updates.
Madam Chair, can I ask a question of Mr. Sullivan?
Yes.
Mr. Sullivan, would you weigh in on this matter? So I think what I'm struggling with is the applicant is saying we have all these obstacles. It's going to be very difficult to move it. It does seem like a pretty minor adjustment when you look at the map. Commissioner Tuma has a very good point, which is an affected landowner. He wants it just out of his field. Seems reasonable. Do you have an opinion on this matter that you could share that would help us to solve the problem? A lot of pressure on you.
Mr. Sullivan.
Chair Sieben and Commissioner Partridge. So when this option came up, it was submitted during the scoping period by Mr. McDonough. And looking at what he submitted in comparison to the proposed route, it became clear that this wasn't really a route alternative that could be separate and distinct from what was proposed. So the reality of it is that the existing route provided enough spatial understanding for us to do the impact assessment. And we recognized that there may be some alignment questions, and those would be best negotiated between the applicants and the landowner, which is largely what we're doing today.
Okay.
So I think that this is the most reasonable course to resolve the situation that we're in now, because it is somewhat congested. You have some unique land ownership as well. And obviously it's an ongoing agricultural practice that is the livelihood of Mr. McDonough. So this is probably the better fit out of all the options.
The current proposal to have the company work with the landowner and then report back to us on the status of that.
Chair Sieben, Commissioner Partridge, yes, that's correct.
Okay.
I'm happy to go there, but I'm watching it.
Sure.
And I think that's the bottom line. I seen that property. I see why Mr. McDonough was concerned about it. He's right, given the distances that the pole's going to probably end up right smack dab in his field, and it doesn't need to be, in my mind. So we'll watch it closely. You guys done a great job through this whole project, so I'm going to assume you're going to do the right thing by Mr. McDonough. And he's my kind of people. I drove by him. He's got a garden as big as my dad used to be, so it kind of brought a tear to my eye. So take care, Mr. McDonough. You got it? Good. I see a nod back there. That's all I need. So you got the language, Emma? Ms. Brugman said, yep.
I just wrote it down in my handwriting. I can try it again.
Can you put it up to Emma?
Yeah. So, the permittee shall work with McDonough to place poles on the property lines and minimize poles in the field to the extent practicable.
Madam Chair, those are all the questions I have.
think you're very reasonable, Commissioner Tuma, in that you're willing to just focus it right down to that area. So thank you. Because then it shouldn't be disrupting the Mississippi River corridor folks or making them concerned about an expanded route width along that whole segment, right?
Yep. So with that, Madam Chair, if you're ready.
I don't know. Commissioner Partridge.
Thank you, Chair. I just wanted to say one thing. I wanted to read something out of the briefing papers that I thought was just a really high-level, important thing to say about it. I think Commissioner Tuma has said this many times over, but I was just really heartened to see the statement that public comments and participation significantly shaped the EA and improved the quality and quantity of information. I think this was just a really good example of people participating in the process, and the process accommodating their feedback and the information and knowledge they were able to provide to the record. And that is just a great example. We expect to see many transmission projects and many of these items come before us. And so I think it was just such a positive thing to see how public participation helped to shape the outcome of the environmental assessment and then the proposed route. The company took a lot of feedback and consideration into their proposed route. And so I just wanted to say, great job, and I hope that this is an example and a model for the many transmission projects we have to come before us in the future.
Couldn't have said it better. So, Madam Chair, I would move decision option 1, 3, 6 as modified, and 8. And oh, by the way, don't need to say again, but it was a good EIS. I'm sure there's a lot of other people helping you out, but it was one that should be held up as an example for future projects.
Any other discussion on Commissioner Tuma's motion? Hearing none, all in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you very much, everyone, for your work. That is it for the day. The commission is adjourned.